Welcome, everyone. Good afternoon and good morning or good evening to participants from jurisdictions other than India. Thanks for joining this session and for this overwhelming response. We have more than 300 registrations today, and the topic obviously is very critical, uh, both from India's standpoint on past actions that India has taken in its own right, and also the future endeavors for attracting more foreign investment and creating a climate of consistency and predictability. So I think the session today, which we have titled as Way Forward for Foreign Investors as India Withdraws Retrospective Vodafone Tax Legislation. The reason why we are, doing this topic is, as you can see in, less than 2 weeks time, this legislation has not only been introduced in the both houses of the parliament, but also has got a presidential assent and is now a law so far as India is concerned. The swift, actions taken in this regard by India demonstrates the importance and seriousness of this issue. And we thought it might be a good idea to, discuss some of the provisions brought in through this legislation, what we call as, the abolishing of the retrospective taxation measures brought in by, 2012 amendments, and also talk about way forward from here. I think it's always important to see things in perspective of future events, more particularly for the private equity, M&A, strategic acquisitions related to India and Indian businesses, where there are foreign investors. The structures are sometimes complicated. Routing those investments through different jurisdictions coming from different countries, but still, there may be certain application of Indian tax measures, and therefore this was always, long-standing requirement from foreign investors as to how do they structure their investments into India. Uh, People were not too much worried on the taxation measures itself, because once you know that this is the tax regime, you can at least have some level of consistency and predictability when you are structuring those transactions. I think the complaint or the grievance of a lot of business community and particularly foreign investors was the aspect that this was brought in with a retrospective effect, and transactions which were 5 years, 7, 10 years old before 2012 were questioned under the 2012 amendment. We are not going into the aspects of what is right at that point in time. Maybe that was the need of the hour at that point in time, what is right now. But what we want to focus on is why this was required in the first place, the recent 2021 amendments, what amendments entail in itself, and then also look forward from there as to how it will affect the deal structuring going forward, particularly for M&A and PE space. So with that introduction, let me introduce our panel as well. All the three speakers are from Nishith Desai Associates itself. We have Ashish Sodani, who is a leader and leads our international tax and international tax litigation practice at Nishith Desai Associates. He is based out of our Mumbai office and has been involved in several of cases which relate to the 2012 amendments, and is also currently advising clients on the effect of this amendment. So he will deal with the aspects of the amendment itself, analyze the amendment and the legislation as it is, and also see some of the applicability in the future on indirect taxation, particularly in light of certain jurisprudence which has already come in, and the effect of this amendment. We also have Shama Loya. She's a leader with our international dispute resolution and investigation practice. She particularly leads our bilateral investment treaty practice and advisory in that regard. And she will deal with the aspects which has led to this amendment, because I think post 2012 amendments, there was a flurry of cases invoking several BITs against India. I think this must be possibly the smallest amendment having maximum number of cases against any country. We may win by far in any race if that was so, in terms of what has led to maximum cases in the world. And this 2012 amendment stands out on its own. So she will talk about that, and also look at nuances which led to this amendment. And then we also have our veteran, Nishchal Joshipura. He heads and leads our M&A and private equity practice with the firm for more than 15, 16 years, and has been involved in several cross-border structuring in this space, and has seen structuring prior to 2012 amendment, considering 2012 amendment, and now, of course, evaluating the effect of those in M&A private equity structuring going forward further. And he will give a perspective as to how this legislation would change some of the complexities and some of the issues involved in the structuring of an India-centric transaction. So coming straight to the topic, and maybe I will straight away go to Shama first. This obviously has not come as a surprise in a way, Shama, in sense people were asking for it, but I don't think anybody was could bet on it that this will come in 2021, or this will come so swift in terms of a legislation. So can you give us a little perspective as to what are the events leading up to this 2020 amendment from 2012 amendment, almost a decade of this legislation of 2012, and the need and the expectation of the business community for taking away this retrospective taxation. If you can give a little bit of your take on this.
Sure. I think India did not realize until about 2008 or 2010 that there was confusion or a lack of clarity in the Income Tax Act on indirect transfers, such as the ones involving Vodafone and Ken. The reason India introduced the amendments in 2012 was to provide, or so it says, provide clarity on the fact that if a company is registered or incorporated outside India, its shares will be deemed to be situated in India if they derive their value substantially from the assets located in India. And hence, the persons who sold such shares of foreign companies are liable to pay tax. Now, when it introduced the amendments in 2012, it had already initiated cases against at least Vodafone. Vodafone case went all the way to the Supreme Court, challenging the measure of the Indian government levying or imposing tax on the indirect transfer that Vodafone had engaged into in 2006. Now, the Supreme Court made a decision in favor of Vodafone, saying that the law as it existed then did not make Vodafone liable to pay tax on the transaction from 2006. So what the government did was, soon after the Supreme Court's decision, which was in January 2012, the government introduced the amendments in 2012. So-called clarification to the law was introduced. But the problem was with respect to retrospective applicability of the amendments. Now, for foreign investors, stability and certainty of legal framework, and more particularly tax framework, is key to plan and make investments. A retrospective application of a law that drastically changes the legal framework and disproportionately impacts foreign investment is against the rule of law. So resultantly, after the retrospective amendments were introduced in 2012, we saw about 4 cases initiated by foreign investors, mainly Vodafone, Vedanta, and Ken, under the India-UK BIT and the India-Netherlands BIT. Now, what are bilateral investment treaties? They are agreements between two countries where the countries guarantee or make certain guarantees with respect to providing protection to investors of the respective countries in their territory. So when the retrospective amendments were introduced, they changed the legal framework drastically for investors from UK and Netherlands, predominantly Vodafone, Ken, and Vedanta. And these investors invoked the India, UK, and India, Netherlands BIT by alleging that India had failed to provide fair and equitable treatment to these investors by retrospectively amending the law. Now, these cases went on for nearly 5 to 6 years. While the cases were on for nearly a decade after introduction of the retrospective amendments, we as a nation struggled on the global platform with criticism from the investor community, governments of other countries, and other stakeholders for not abiding by the rule of law and for breaching our international commitments under bilateral investment treaties, and generally for drastically changing the law and disproportionately impacting investment. Now, while this was on late last year, in September 2020, award was rendered in the Vodafone case. And in December 2020, an award was given in favor of Ken in the case that Ken had initiated under the India-UK BIT. Both these awards went in favor of the investors, basically Vodafone and Ken. Now, that brings us to the present situation where, while the award in Vodafone is mainly only granting reimbursement of legal costs of Vodafone to Vodafone, but in the Ken case, there has been a drastic award against India. India has been directed to pay $1.2 billion towards loss of net proceeds, which Ken would have earned had India not seized Ken's shares pursuant to the tax demand, and certain other tax refunds that are due to Ken. So overall, there is an award of $1.2 billion against India in the Ken case. And Ken is rigorously enforcing this arbitral award in various jurisdictions, more than 8 jurisdictions. We are hearing, obviously, of the most important ones from US and France, where Ken has initiated proceedings against Air India to attach assets of Air India, which it claims to be an alter ego of the government of India. And it has initiated case against Indian assets and attachment of Indian assets in France, and the French courts have recognized the award and would be enforcing the award in France. So that brings India really into a very critical situation where its assets are being sought to be attached in jurisdictions outside India. And obviously, this has brought to the fore again criticism from the investor community. There is obviously a negative sentiment and an investment climate that is not very fortunate for India at a time where India is coming up as one of the largest investment incoming countries, where countries are looking at India as a market to invest, but thanks to these drastic changes in the law, the investment climate in India is being impacted. So that brings us basically to withdrawal of the retrospective applicability of the tax amendments. Now, important to note that the amendment has not been taken away from the statute book. What has been taken away is the retrospective applicability of the amendment. That's one. Two, while India could have just attempted to settle the disputes with Vodafone and Ken, it has gone ahead and taken a larger step by withdrawing the retrospective applicability of the tax amendments, which also covers more cases, 15 more cases, in addition to the Vodafone and Ken case, where investors and where stakeholders will benefit from the withdrawal of the retrospective amendment. So the reason why India seems to have withdrawn the retrospective amendments are basically twofold. One is to reinstate the damaged investment climate and the reputation for the last 9 or 10 years due to the retrospective applicability of the amendments. And two, to nullify the tax demands and to make an attempt to settle the disputes with Vodafone and Ken by altogether removing the tax demand subject to Vodafone and Ken complying with certain conditions. Back to you, Vyapak.
Sure. No, thanks a lot. And I think what has possibly, raised alarm bells, right? And I think everyone talks about why would, tax measures come under the scrutiny of bilateral investment treaties. They are always sovereign right for the countries, and this should not be the kind of awards which can go against India. But I think what is, something which is a miss in that logic and that interpretation, which is generally true, that taxation measures should be something which should be kept to the sovereign, and bilateral investment treaties should not have any claim for such measures so long as the other aspects of your commitments under the BITs are taken care of. But I think what made these cases go against India, possibly one big reason could be the way it was implemented, right? After the Supreme Court order came in favor of Vodafone, and immediately 2012 amendments were, brought in, and more particularly, it was then applied retrospectively for transactions even prior to 2012. So I think that is where now when investors are going very aggressive, in terms of implementing those awards or enforcing those awards in several different jurisdictions in India, outside India, I think, this is something which is a welcome step in my view, because these are kind of matters which are best resolved and settled, and this is possibly the best attempt that India could make in that regard. So with that background, if I may ask Ashish to come in and explain the amendment itself, what all it entails, and how it will be applied in the Indian context, particularly in light of the language of the amendment, and also the manner in which such settlements apply in Indian legislations.
Sure. Thank you, Apak. I hope I'm audible. So
Yeah.
the 2012 amendments were made to Section 9 of the Income Tax Act. Section 9 is a deeming provision which says incomes which are deemed to accrue or arise in India, and generally tax non-residents with respect to incomes that they are earning from India. So, in a situation where a foreign entity would be selling shares of an Indian company, Section 9 would be attracted, and there would be a tax payable by the foreign entity. Similarly, the indirect transfer provisions were also included under Section 9, where if a foreign entity directly or indirectly held uh, Indian company shares or interest, then there would be an indirect transfer that would become applicable. This was, of course, brought about through various explanations and provisions, which have, of course, been challenged over the years, like Shama was pointing out, in various courts. But considering the amendment is what we are discussing here, um, I'll break it up into three parts. The first part being that if there has been any kind of assessment or reassessment that has been made under the Act with respect to any non-resident, or there has been a demand that has been enhanced, or a refund has been reduced, or there has been a order passed with respect to holding a person to be an assessee in default. An assessee in default is an assessee, could be an individual or a company who had to withhold tax but did not withhold tax, and therefore is considered to be an assessee in default. Now, in these three situations where there has been an assessment or a reassessment, or there has been an order enhancing the assessment or reducing the refund, or there is an assessee in default situation, then in such situations, the provisions will not be applicable. That is what the first part of the amendment says. The second part says that where an assessment has been made, or a notice of assessee in default has been issued, or an order has been passed, uh, then in those situations, these orders or these notices would be considered to be null and void from the very beginning, which means it would seem as if they have never existed in the very first place. This is how the government of India is essentially trying to tackle the situation of, Vodafone, Ken, and the others, because by virtue of the provisions itself, there is going to be a uh, uh, nullity in the demand and notices that would have been raised against these entities, and therefore there is going to be automatic nullity to the demand that may have been raised or a notice would have been issued. Uh, However, what is concerning is the fact that the uh, refund, if any, has to be issued by the government of India to the assessee or the taxpayer, is going to be refunded without any interest becoming payable to the assessee, which means that if there was a payment made by virtue of the indirect transfer, uh, then the money would be returned, but not the interest that otherwise would have been returned by the government in case a demand would have been raised and tax would have been paid. This is slightly concerning because in 2012, if an amendment, if an indirect transfer would have taken place and tax would have been paid, and this would have been challenged, then in that situation, you would have you would have earned interest for 10 years, which is not being paid now by the government. Uh, the last part of the provisions provide how the provisions will take effect, which is basically that if there is any kind of an appeal or a writ petition that has been filed in any of the forums, which could be the tribunal, high court, or the Supreme Court, then the assessee has to withdraw or submit an undertaking to withdraw such appeal or writ petition. The second is, in case there has been an arbitration proceeding that has been initiated, or a conciliation or mediation, then that also has to be withdrawn, or an undertaking has to be submitted. Now, this undertaking that has been discussed in these provisions is something that the Central Board of Direct Taxes has to come out with. and the form and manner will be then discussed at that point in time, and whether those details that the Central Board of Direct Taxes is asking for in that undertaking is acceptable or not, we'll come to know only once the form of the undertaking is available. So this is where we stand with respect to the provisions, and this is how the government of India is uh, trying to take back the retroactivity of the provisions. Like Shama said, the provisions will still be applicable prospectively, which means any transactions that have taken place after 28th May 2012, which is the cutoff date as per the provisions, would still would still continue to be taxed under the indirect transfer provisions, but anything that has happened before that would be subjected to these provisions, and therefore there should not be any indirect transfer applicable to them. And the fate of those companies and assessees would be determined as per what they want to do, considering this amendment. Vyapak,
Sure.
over to you.
Yeah, thanks. Yeah, thanks a lot, Ashish, on explaining the amendments, and maybe I'll come back to you on this in a little while. But before that, going back to Shama, on some of the existing disputes she already spoke about, and as we were discussing earlier, there are several cases at different stages pending arising out of the 2012 amendments. What is your take on the impact of those cases, and how would this legislation change the course of those proceedings in the near future?
I think it's helpful to divide disputes into probably four buckets when we look at withdrawal of the retrospective tax amendments. One, and I'm not talking about the four disputes that emanate from bilateral investment treaties that are already in the public domain. There might be some that are confidential. There might be some we don't absolutely know about. So the first bucket of disputes could be those where notices have been issued by the income tax department, but a demand has not been raised after those notices. Now, if there are any such cases, then investors can be assured that no demand will be raised anymore by the government pursuant to those notices that they may have issued earlier. The second bucket of cases would be where demand has been raised and payment of the tax demand has been made by an investor. In that case, if the investor has not challenged the tax demand, then has gone ahead and made the payment.
Yeah, Shama, your voice is going little feeble. If you can be closer to your mic, or
Okay, is it better now?
yeah, this is better.
Okay, my apologies. So the second bucket of disputes I mentioned is where demands have been raised and payments have been made pursuant to those tax demands by investors and have not been challenged by the investors. Now, in that case, there is no recourse to available to the investors. They cannot claim a refund from the government pursuant to this withdrawal of retrospective tax amendments. The third bucket of disputes would be where demand has been raised, payment has been made by the investors, and investors have also challenged the tax demand. Now, in that case, if the investors comply with the conditions that Ashish mentioned, basically, if they give an undertaking or if they withdraw the challenge that they have made to the tax demand, and additionally, if they waive their right to pursue any remedy that they may have with respect to this demand, then the government will go ahead and
So,
nullify.
sorry, Shama, your voice gets muddled, but can you go a little slow, or maybe,
Sure.
yeah. So maybe till the time you fix your microphone, if I can bring on the same aspect, Ashish, as well, because this is something which, is going to go through different stages in before the income tax department. And before Ashish, you start, just to remind all the participants, you can put your questions in the Q&A session. We already have few questions, and possibly what Shama was addressing will also address Krishna Mundada's question regarding what are the cases pending and how it would be dealt with. We will deal with the other questions shortly during the session itself and not at the end. So please feel free to put in your questions as we speak. But Ashish, if I can bring you on what Shama was talking about and your uh, view on some of these issues in law which would affect the settlements and the cases which are at different stages before the income tax department and also at different stages in the BIT cases.
Sure, Vyapak. So I think what Shama was trying to point out was the various scenarios under which the taxpayer would be eligible for a refund or nullity of the demand or notices. I think she pointed out that in situations where effectively there is a demand that has been made or an order has been passed and the same has been challenged, notwithstanding the fact that the demand has been paid or not, then in those situations there is the provisions provide that you are going to get the refund or the order will be considered to be null and void. But in a situation where you have not gone ahead and challenged the provisions, in those situations, unfortunately, there is no recourse available as per the current provisions, which results in some kind of concern arising because you are left in a position which is not really at par with the others who are also affected like you were. Uh, so that is one broad issue with the provisions. The second issue to my mind is with respect to the non-payment of the interest, which I touched upon. So I will not dwell too much into that point. But the non-payment of the interest for provisions which were brought about 10 years ago seems quite concerning, and we'll see how it all plays out in the next few days with respect to all those who are settling with the government of India on this point. The third issue is with respect to the undertaking that is still to be made available. The Central Board of Direct Taxes has not yet come out with any kind of undertaking. The law was passed sometime last week and was given precedence assent also. What this undertaking is going to contain is a question that remains to be answered. Uh, Broadly thinking, giving such powers to the CBDT, may not result in something which is, favorable, is what experience says, and therefore it is going to be a wait and watch situation on what exactly is the undertaking going to say. Also, additionally, will an undertaking result in everything going off for the taxpayer is also something that we will have to see once the undertaking format is out. Of course, from a Kane and Vodafone perspective, they will need to understand what kind of details are being provided, are required rather by the CBDT for this settlement process to continue. The fourth point that I'd like to make mention here of cases where there has where which potentially may not be covered by these provisions. To give you an instance, the provision provides that an order that has been passed, right? Now, in a situation where you have an advance ruling which has said that a demand that the provision should be applicable in a particular transaction. Now, the question there is whether that ruling can be considered to be an order. And in an advance ruling, after the advance ruling gives its ruling, there is no consequent demand raised by the advance ruling itself. It needs to go back to the assessing officer who would then pass a demand. Now, in a situation where I have challenged the advance ruling by way of a writ to the High Court, uh, I may withdraw the writ petition, but I still don't have an order. So then in that situation, am I still covered under these provisions or not? Becomes a question that needs to be answered. And we will see, with discussions with the CBDT as to how they react to such a situation. Similarly is the case of a notice, right? There would be a notice that has been issued, but nothing beyond that. Are we covered by these provisions only at the notice stage where there has been nothing else that has happened? I think these are some problems that we are
Sure.
looking at. Yeah, Vyapak, over to you.
Yeah, sure. Thanks a lot, Ashish, for explaining those aspects, and we'll obviously look at those points. But let me bring Nishchal. He's been listening to us for a long time, and I think before even I could, put questions to him, there are very relevant questions put by some of our participants, and maybe I would straight away, put them, because that is something which I thought Nishchal would anyways cover, which is Hemant Srivastava asking what kind of changes can be witnessed and expected in the PVC space in India post this amendment. Any impact on new FDI, FPI investments 2021 onwards, with regard to this aspect. And the last one from Freni Patel is also very interesting, which is after scrapping of this retrospective tax, have an impact on indemnity tax insurance when it comes to M&A deals. So maybe Nishchal, if you want to cover this 2 or 3 questions, and thank you participants for making my job easy.
Sure, Vyapak. I will cover these 3 questions. But before I start, I think when this amendment was made in 2012, I heard 2 very interesting statements from 2 different people. The first one was that, this retrospective amendment has ensured that in India, not only your future, but even your past is uncertain. So the Indian government can even change your past through retrospective amendments. So don't be so comfortable that something that has got over is not going to change for you. So this was an interesting statement. And second statement that came was that, the government was generous in extending this only till 1961, because there were previous income tax acts also in 1922, and the first income tax act in India was introduced in 1860. So the government was generous to restrict it only till 1961 and not go till the first income tax act when it was introduced. So I think since then, all of us have read a lot about this topic and have been discussing this. And we have been spending a lot of time on negotiating tax indemnities in cross-border M&A deals and private equity deals. And one of the interesting experiences that I personally had was in 2013 when I was negotiating a cross-border deal where a US company was getting acquired by another US buyer. And that US company had a major subsidiary in India. So substantial portion of its income was and revenues were coming from India. And this was actually the first case where there was actually a double indirect transfer issue. Usually you have only a single indirect transfer issue where if you're buying a foreign company which has substantial operations in India or assets in India, then you negotiate the tax indemnity. But here what had happened, we were representing a foreign buyer for acquiring a US company. And not only was the transaction that we were discussing was subject to indirect transfer related issues, but the target company had also acquired another foreign company which had substantial operations in India just 3 years back, before the transaction that we were doing. And that target company had not negotiated any tax indemnity with the seller of the company which they had bought. So what would have happened is, if we would have not negotiated a tax indemnity for what the target company did by not getting tax indemnity from their seller, we would have been doubly hit, one for the transaction that we did, and second was for the transaction that the target company did 3 to 4 years back. So this was, as I mentioned, a case of double indirect transfer tax issue that we negotiated. So to answer the first question on what's going to be the impact on private equity and M&A deals. I think one clear impact is we don't have to worry too much about the history of how the shares were acquired prior to 2012. So all the discussions now would be post 2012 on how the shares were acquired by the foreign company of Indian company and whether indirect transfer tax gets triggered or not. The other point on reps and warranties and indemnity insurance, clearly it would be easy for the insurance companies to take a call on these issues now, given that all transactions May 2012 have been grandfathered and they won't be opened up by the tax department on indirect transfer side. Of course, the issues between 2012 and 2015, till when the 50% threshold was not defined, those ambiguities will still remain under law, and what substantial would mean, and some of those concepts will still apply. But largely, this does reduce the burden of negotiating indemnities both for the buyer and the seller, and at the same time, the insurance companies also would be much more comfortable insuring the tax risk prior to 2012. Now, one question that keeps coming up is there any way where we can avoid this indirect transfer tax, right? Or is there any tax planning that can be done to avoid this tax in India? We have been working on quite a few SPAC structures right now. As you all know, SPAC is the flavor of the season, and Renew Power, the largest SPAC, which is going to get listed on NASDAQ at $8 billion enterprise value, has resulted in a huge demand for SPACs for Indian businesses. So we are working with 3-4 players in India who are looking at listing their Indian businesses through US SPAC structure. And one of the major issues that comes up is when the foreign company gets listed on NASDAQ or NYSE, the foreign company's major business would continue to remain in India. And all the shareholders who will be in the foreign company will, depending on what percentage of shares that they are holding, they will be subject to indirect transfer tax at the time of their exit from the NASDAQ listed company. So few structures that we have looked at and devised to take care of the indirect transfer tax issue. I can quickly share some of those that we have used in the past and that don't qualify as indirect transfer as per the Indian Income Tax Act. So the first structure that we have used is, the investor in the foreign entity which owns the Indian asset. We set that investor up typically in Netherlands. Now, Netherlands we have started using a lot for India dedicated funds, where the pooling of money is happening from offshore investors. Netherlands, India is the only tax treaty now which exempts capital gains tax in India. If the Dutch entity is owning less than 10%, or if it is owning more than 10%, then the transfer of shares is to a non-resident. So Netherlands is one major jurisdiction which can be used to even avoid the indirect transfer tax issue. We have also been seeing use of Mauritius and some of the other jurisdictions, subject to the final outcome on the Sanofi case, which is pending at Supreme Court level. To also take an interpretation that, as per the India-Mauritius tax treaty, transfer of shares of a foreign company falls in the residual clause, and hence there should not be any tax implications in India. So use of Netherlands, Mauritius is the first structure that can be used to avoid indirect transfer tax. The second structure, which is provided in the Income Tax Act itself, where if you are owning less than 5% shares in the foreign company and you don't have any control or management or any significant rights, then that itself is an exempt transaction. So that's the second structure that is typically used to see if the shareholding can be kept below 5%. The third structure that we have used is to use category 1 foreign portfolio investor entity. As all of you might be aware, there was an exemption that was granted by CBDT that if a Cat 1 FPI entity has invested in India and is redeeming the shares of the shareholders, then that won't be subject to indirect transfer tax. So while traditionally Cat 1 FPI entities have been used only for making portfolio investments, that is investment in listed companies to buy and sell shares on the exchange, we have in few situations also use FPI entities or Cat 1 FPI entities for making FDI investments, foreign direct investment in unlisted companies also, because FPI entities are allowed to invest under different routes. So for listed investment, they can choose the FPI route. For unlisted investment, they can still continue to invest under FDI route. And with that, it is possible to take a view that any redemption of shares of FPI should be eligible to claim an exemption from indirect transfer rules. The fourth structure that we have used is the dividend model. Instead of redeeming the shares of the foreign company, just distribute the profits as a dividend instead of doing a capital reduction or redemption of the preference shares in the foreign company. Dividend, again, as per a CBDT circular, has been exempt from indirect transfer provisions. So that's the fourth structure that we have used. The fifth structure, which is quite unique, which we used for one of the restructurings, so is the structure that is applicable only if the foreign company which owns majority of its assets in India is a Mauritius company. So just like in India, we have the concept of share capital and share premium, right? So for example, let's say a foreign investor is infusing, let's say 100 rupees in an Indian company where 10 rupees is the face value and 90 rupees is a share premium, right? In Mauritius, there is a concept of what they call stated contributions. If you're putting in 100 rupees, 10 can go towards share capital and 90 can go towards stated contributions. And what you can do, just like unlike in India, where if you are redeeming the shares, you have to partly reduce the face value and partly the premium. In Mauritius, there is an option to just reduce the stated contribution without touching the share capital. Now, when you do that, if you don't touch the share capital, there is no question of indirect transfer that happens at the Mauritius level. And you can still end up getting your money back through the stated contributions without touching the capital structure. So this is another one that we have used to, as a carve out from the indirect transfer provisions. And the last one that we have used is, the debenture structure instead of the share structure, because the indirect transfer provisions apply only for transfer of share or interest, and interest is more to do with the partnership interest. So if you are using a debenture which has qualities of debenture also, like let's say it's secured with a pledge of shares and it has it has downside protection and at the same time you build some equity upside to that instrument, it is possible to even use the debenture as an instrument. And when the company redeems the debenture as an instrument, at that time, there again should not be any indirect transfer tax. So these 6 structures, we have been using to, to help our clients, not to help our clients with respect to the indirect transfer tax planning. I think broadly, I think this covers all the 3 questions. One couple of questions were on how it changes things, as I mentioned. The tax indemnities pre-2012 need not be negotiated because it's now straightforward. And reps and warranties insurance, hopefully maybe some premium should reduce for the tax insurance, for the withholding tax especially, given that there is more certainty prior to 2012 on the risk for the insurance company. So I think this is broadly, Vyapak, what I have seen on the deals and how the structuring has happened.
Sure. No, thanks a lot, Nishchal, and I'll come back to you with couple of more questions as they pop up in the window. But in the meantime, if Shama, you are back and if you're you are audible well, there is an interesting question from there is an interesting question from Abhishek Singla on the probability of companies like Vodafone and Crane seeking refund. Now obviously we can't predict what other companies would do and how pros and cons for them, considering their own, issues. But if you have any take on that aspect of how these settlements would occur and whether this, uh, you know, uh, people would prefer refunds over enforcing the arbitral awards.
Absolutely. This is a great question. And in fact, this is what I was going to cover in the question earlier on what is the impact of these amendments on the cases of Vodafone and Ken. I'll start with Vodafone first because these cases cannot be compared. In Vodafone, there was a demand and an interest and penalty demand as well. Now, Vodafone did not pay uh, the demand and contested the demand under the India Netherlands as well as the India UK BIT. Now, the award that has been given in favor of Vodafone is to direct India to cease its conduct pursuant to the tax demand, which means that India should not continue to pursue the tax demand against Vodafone. And two, India was directed to reimburse legal costs of $4 million to Vodafone. Now, India has challenged this demand or this award before Singapore courts, and which effectively means that India is trying to reinstate the demand that it made on Vodafone. Now, pursuant to the withdrawal, if Vodafone gives an undertaking not to pursue the award or initiate any proceedings, which will mean to recover the 4 million legal costs award that Vodafone has in its favor, then India will nullify the tax demand that it has made against Vodafone. There's no question of a refund by India because Vodafone has not paid any tax. So even if it withdraws any proceedings or does not pursue its claim for those legal costs that are awarded, there's no question of India making a refund. So all that India will be doing is to nullify the demand if Vodafone does not pursue the award further or does not
Understood.
claim those 4 million in legal costs. So Vodafone is fairly clear. It can forego the legal costs and, the dispute will be over. For Ken, the
Understood.
situation is complex. For Ken, a demand has been raised. Again, Ken also, like Vodafone, did not pay the demand and contested it in arbitration. But while arbitration proceedings were on, the Indian government took several measures pursuant to the tax demand. One, India seized shares of Ken, uh, which valued around $1 billion at the time in 2016. It sold part of those shares and realized some $216 million. It also seized certain dividends that were due to Ken and sought to offset a tax refund that was due to Ken on a separate transaction. Now, the award that has been made in favor of Ken is that India will pay about $1 billion for net proceeds that would have been earned by Ken from the planned sale of shares in 2014. So basically, if the Indian government had not seized the shares, then Ken would have gone ahead with the sale of shares and would have earned certain proceeds from it. Because Ken could not earn those proceeds, those should be paid by the Indian government. And second, obviously, certain tax refunds that the Indian government had withheld, those should be made good to Ken. So now with the withdrawing of this retrospective tax, if Ken gives an undertaking that it will not pursue the award or it will not try and enforce the award against India and it will not, it waives its rights to pursue this claim, India would have to refund the taxes that it withheld, which is a small proportion of the $1 billion award. What majorly remains with that 1 billion award are the shares that are still with the Indian government that it has seized or it had seized in 2016. Now, if
Understood.
the government reinstates or unseizes those shares, then Ken gets back those shares, but then there will be issues around valuation of the shares. Because what was the valuation in 2014 would be different from what it is today, and whether India would be filling that gap for seizing Ken's shares, that will be an issue that will be faced by Ken, and hence it is trickier to predict if Ken will go ahead with withdrawing the arbitration proceedings as opposed to Vodafone, which has nothing, which has not much to lose by withdrawing the dispute.
Understood. So I think as we see, there are quite a few moving points on both the cases and other cases which are other than these two cases as well. So I think this space is going to be more and more interesting in the next few days. But that brings me to another question, and maybe Ashish, you can answer this. That is from Pooja Chajar, that the amendment says that all orders would be nullified. Would it cover cases where there is no challenged by taxpayer?
That's right. So I think the order would be nullified, but in a situation where the taxpayer have actually made payment of the taxes by virtue of that order, but not challenged it, the provisions don't provide for any kind of refund to be given in those cases. It is only when you are withdrawing your appeals or giving an undertaking that you are not going to pursue them further, only in those cases will a refund be applicable. Therefore,
Understood.
in situations, yeah.
And there is another question from Frani Patel on what do you meant that it is not ideal for CBDT to come out with the form of undertaking?
Right.
What are your apprehensions?
So I think the primary apprehension here is the fact that the amount of detail and what kind of detail will CBDT be asking to give an undertaking. Further, an undertaking to not pursue a legal battle is something which needs to be properly thought through, because the language in the provision as it is currently stated is very wide and resulting in it could result in situations where you cannot take on a battle with the government of India on particular aspects, which may not be the most ideal thing. So I think that is the primary concern.
Understood. And maybe we are just close to 5 p.m., but we can take one more question. And Nishchal, if I can bring you again as a last speaker on this. There is a question from Gaurav Jindal, and you talked about the Netherlands structure. And I think the question is how can Netherlands be used to structure this having regard to MLI?
Sure. Yeah.
If
So
you
I
can
think,
if you can give an
yeah,
answer quickly, because we are
yeah,
just
yeah.
close to 5 p.m.
Less than 1 minute. So I think the basic principle still remains that your structure has to meet with the test of substance. The question is whether it's MLI or treaty GAR or domestic GAR, right? We are living in a new world now where you can't have just the shell companies invest and avail of treaty benefits, right? So the basic structure still remains. The question is, what are the non-tax justifications that you can use for setting up those structures? And which is where we have been spending a lot of time with our clients to build non-tax justification for the structures. So for example, the first thing, non-tax justification for using Netherlands as a structure would be to say that Netherlands has the best bilateral treaty network in the world, right? Today, more important than saving taxes is to protect your investment and capital when you invest in a foreign country, right? So some of these things become very important, and we spend a lot of time in drafting some of these things in the minutes, in the board minutes, in any application that needs to be made to the regulators, local regulators, to ensure that everything is documented, that this investment is being made keeping in mind the non-tax considerations also for making investments. The other interesting substance justification in Netherlands is amongst the best holding companies jurisdictions in the world today, right? maximum holding companies in the world are set up in Netherlands for investments in Europe and other jurisdictions. So I think there are many justifications that can be used for use of Netherlands in the structure. And once you use it, you are out of the indirect transfer tax issue.
Yeah. No, thanks a lot. Thanks, Ashish, Shama, and Nishchal. I think that obviously more questions which are going to flow as we speak and as things progress in this direction. Only last question, I think, from Krishna is related to enforcement of BIT awards. There is obviously a whole topic in itself, but yeah, I think the biggest problem of enforcing BIT award in India is that there is no specific regime. And the question always occurs that whether it will fall under part 2 of the Arbitration and Conciliation Act, which may it not. And then if not, then what is the regime for enforcing those awards? Unlike many other jurisdictions who have a specific regime, but there is a detailed paper on this written by NDA, and maybe we'll share it with you. And if there are any follow-up questions, we'll be happy to answer. So I think with that, we come to an end of this session. We are, almost at 5 p.m. But we'll be very happy to answer further questions. If anybody has, you can write to us individually or any one of us, and we'll be happy to answer. And as I told, the way things are going to unfold in this area, there will be very, very interesting questions which will arise, and we'll definitely come back with another session on the updates on this space. So thanks a lot, everyone, and thank you, speakers, for giving insights on this topic.